Electoral bonds scrapped a month ago. They were declared unconstitutional by the apex court of the country, the Supreme Court, in middle of the February. But they still continue to hit the headlines. Of course, for the different reasons, but we need to understand that why are they so important. But before we understand their importance, let us first go back to 2017 when they were introduced. Why were they introduced? Then why years down the line the need of their scrapping arose? And then why after the scrapping also, months after the scrapping, they are still relevant, especially right ahead of the Lok Sabha elections. Let's understand in depth. In 2017, the Indian government introduced electoral bonds, a novel approach to political funding. These bonds allowed individuals and corporate entities to make anonymous donations to the political parties, claiming to promote transparency. However, the anonymity they had provided raised concerns about the accountability of the potential misuse. Critics argued that the lack of disclosure regarding the source of these funds posed a threat to democratic processes. Now, let me quickly take you through 7 comprehensive points that why electoral bonds were a threat to the democracy. Number 1, anonymity. Donors could contribute to the political parties anonymously, safeguarding their identity, which means no donor had to reveal how much they were donating to what party. Second of them, legal framework. Introduced through the Finance Act of 2017, electoral bonds aimed to streamline political funding through the banking channel. SBI was involved to make these things streamlined. It was the only bank that could lend these electoral bonds that were further encashed by the political parties. Third, eligible parties. Only registered political parties meeting specific criteria were eligible to receive funding through these electoral bonds. Fourth of them, denominations. Now, these electoral bonds were available in various denominations ranging from Rs 1,000 to Rs 1 crore, catering to the donors of diverse capacities. Now, any donor could donate any amount of the money to these political parties, and they came with tax exemption. Purchase period. Fifth of them being the purchase period. Donors could purchase these bonds during the designated periods announced by the government, typically 4 times a year. Sixth of them was validity. With validity of 15 days, electoral bonds required parties to encash them within a limited time frame. Seventh and the last, transparency concerns. Despite the government's claims of transparency, the lack of donor disclosure raised transparency concerns among the critics. Now, the electoral bonds were scrapped because there was no check on the donors. No amount, there was no regulation on the amount, how much a donor could donate to the political party and which political party. So, to curb them all, the apex court, the Supreme Court in mid-February scrapped them. But in the latest development, let's now shift our focus to the latest development. What is going on currently? Now, let's shift our focus to the latest development surrounding the electoral bonds. The Supreme Court's recent directives have brought the electoral bond scheme under the scrutiny. The court has ordered the State Bank of India to disclose all the details related to the electoral bonds, including the serial numbers, emphasizing the need for transparency in the political funding. The Supreme Court today directed the SBI to disclose all details related to electoral bonds that allowed individuals and companies to make donations to the political parties. This must include serial number of each bond, said 5-judge bench headed by Chief Justice of India D.Y. Chandrachud. We want all the information related to the electoral bonds to be disclosed, which is in your possession, said CJI Chandrachud while hearing the petition against the incomplete data provided by SBI on the donations made through electoral bonds. The court directed SBI chairman to file an affidavit by 5 p.m. on Thursday stating it has not suppressed any details available to them. It also asked the Election Commission to uphold the details once they get it from the SBI. The court struck down the electoral bond scheme last month and directed the bank to share all the details on the donations made in the last 5 years. It had also sent a notice to SBI saying that the data provided on electoral bonds was incomplete. The SBI's attitude seems to be like, you tell us what to disclose and we will disclose. That does not seem fair. When we say all details, it includes all conceivable data. All details should come out. We want to ensure that nothing has been suppressed, said the Chief Justice of India today. Stating the SBI can't be selective in disclosing the details, he said, "Do not wait for the orders of the court. We bank on the fact that the bank will be candid." The SBI was earlier criticized for not sharing any link between the donors and the recipients of the electoral bonds, after which the Supreme Court ordered them to share the bond numbers. However, lawyer Harish Salve, representing the SBI, said the alphanumeric, a unique figure mentioned on each electoral bond that can be read only under UV light, is the only security feature that separates from the audit trail. Justifying why the data provided by the SBI does not link with the donors with their recipients, he said the purchase and the redemption data of the electoral bonds were stored in two separate files since the bank was under the dictate of anonymity. That's all on the electoral bonds for now. For more latest updates, stay tuned to the Savera.